5 seconds to go. Start. The candidates will be selected and allotted to the residential educational institutions societies in Telangana state as per the option exercised and as per their rank in the merit list and as per zonal preference for allotment of candidates against available vacancies after verification of certificates, community and category wise for the vacancies available as required. Thus, the candidates were duty bound to exercise their options, and the allotment would accordingly be made as per their rank in the merit list based upon zonal preference. In other words, no candidate will be considered to any other zone not opted for, and therefore such consideration is confined among the ones preferred. For the sake of clarity, if a candidate could not get allotment in their first preferred zone for want of merit in the zone that they belong to, they shall be considered in the second preferred option. Respondent numbers 1 and 2 belong to roster point number 2, scheduled caste women. Respondent number 1, being a local, sought her first preference for zone 6 while it was the second choice for respondent number 2 after zone 5. Respondent number 2 on merit obtained 35th rank while respondent number 1 stood at 49th rank. Respondent number 1 filed a writ petition inter alia contending that the ratio has to be at 40-60 and she, being a local with her first preference under zone 6, ought to have been recruited as against respondent number 2. The learned single judge proceeded to allow the writ petition by fixing the ratio at 40-60 and held that there was no basis for fixing the reservation, while respondent number 2 ought not to have been permitted to be considered under zone 6, that being her second preference. Incidentally, it was held that out of the 7 vacancies, 4 vacancies had to be filled by following the rule of reservation, leaving 3 remaining vacancies for the unreserved category. This view of the learned single judge was approved by the division bench, forcing the appellant to approach this court. Learned senior counsel appearing for the appellant submits that both the courts have not taken into consideration the amendment made to GOP number 763 dated 15th November 1975 wide GOMs number 124 dated 7th March 2002. There were actually 7 posts, out of which 5 were earmarked for local reservation. Out of the remaining 2 vacancies, one was to be filled up by scheduled caste women. Respondent number 1, being ranked below respondent number 2, was not considered. In any case, there is absolutely no bar for a candidate to be considered in a different zone provided that such option is duly exercised. The said submission is reiterated by the learned counsel appearing for respondent number 2. Per contra, learned counsel appearing for respondent number 1 submitted that no fair procedure was adopted. The High Court has rightly considered the ratio and granted the relief. Stop.